I'm Rick Harp. This is your APTN News Brief for Monday, February 12th. We begin with a major decision by Canada's Supreme Court, a unanimous rejection of Quebec's constitutional challenge of Bill C-92, the federal law assigning exclusive Indigenous control over child welfare services. With more on the ruling and reaction, Fraser Needham.
It was a day of bittersweet emotions, as Assembly of First Nations Regional Chief for Quebec and Labrador, Ghislain Picard, pointed out at a press conference in Ottawa.
It's a very beautiful, a happy decision by the Supreme Court, but it is also, in a way, a sad day that the well-being and the future of these children has been an issue debated before the courts for the past 4 years and beyond.
The Supreme Court ruled against Quebec's challenge that Bill C-92 infringed upon the province's jurisdiction. In a more than 100-page decision, the court finds there's nothing that prevents the federal government from affirming Indigenous people's right to self-government as set out in Section 35 of the 1982 Constitution, and the act is valid in establishing national standards that give Indigenous people control over their children's welfare. Also at the same press conference, Derek Montour of Ganawaki Community Services said the court decision confirms what Indigenous peoples have long known.
This ruling reiterates the message that we have been emphasizing for years, that First Nations, Inuit, and Métis are best placed to ensure the wellness of our own populations. Following today's decision, provincial governments and even the federal government no longer have any reason to abstain or discredit the legitimacy and competency of our governments.
Picard added First Nations have had a strained relationship with the province in recent years, but this is an opportunity to reset that relationship.
The fact that we are forced before the courts will certainly limit the good faith on our part, and we've always conveyed and believed in the position that our peoples have compromised enough. I think it's time now for other governments to do the same. I think that's the only way that trust and good faith will prevail.
Indigenous Services Minister Patty Hajdu said at another press conference on Parliament Hill that it is a historic day, where Canada's top court ruled in favor of Indigenous people's inherent right to oversee and draft laws that affect their children's welfare.
This decision by the Supreme Court to uphold that inherent right, to recognize the legitimacy of federal law, to bolster that right and to place that right in Canadian law, I think is going to have tremendous impact across the country.
APTN News reached out to the Quebec government for comment. In an emailed statement, Minister of Social Services Lionel Carman's office says the dispute has never been between the government and First Nations and Inuit people, but with the federal government. It also says it will continue to work with First Nations and Inuit groups in the province, and that it will need time to analyze the Supreme Court's decision. It also says the interests of the children will always come first. Fraser Needham, APTN National News, Ottawa.
Cindy Blackstock heads the First Nations Child and Family Caring Society. She has her own history with the Supreme Court.
Well, this was an incredible victory for First Nations, Métis, and Inuit kids, in that it affirmed the national standards and saying, look, no more harming kids in legislation and other policies with child welfare. All governments have to do better. That's a good thing. And then in addition to that, of course, affirming the decision-making of First Nations, Métis, and Inuit children for their kids. All of this great decision, though, what I always say, it's a great dream, but to make it a reality, we got to make sure governments implement these things. And right now we have a non-compliance order, for example, against the Canadian government for breaching Jordan's principal orders. They need to bring their actions in alignment with this judgment and the requirements of the Act respecting First Nations, Métis, and Inuit children, youth, and families. I'm hoping that what we're going to be seeing is Canada actually affirming that First Nations laws have application across all provincial jurisdictions. There's been this tendency for them to say, well, it only applies in the province where the First Nation is. That should be out the window. Number two, they need to comply with the Canadian Human Rights Tribunal orders fully so that those national standards are met for First Nations communities, and make sure that those hard-fought wins on Jordan's Principle and Child and Family are a baseline level of funding for First Nations, regardless of what jurisdictional model they want to achieve. Because the bottom line is every First Nation wants to make sure that their children grow up healthy and proud in keeping with those standards.
Still with reaction to the Supreme Court's recent ruling, Bobby Narcisse is Deputy Grand Chief of the Anishinaabe-Aski Nation, a coalition of 49 First Nations in Northern Ontario.
We've asserted that our children, our families are our jurisdiction, wherever they may reside. And this new ruling really supports our inherent rights on children, youth, and families. So we welcome the Supreme Court's decision on this particular matter. We strive to move ahead in terms of determining our own future with respect to revamping child and family services, not just protection, but also how do we support the families? How do we move from an era of apprehension to prevention and more or less preserving the family unit? And it's our young people and our young parents especially that we really hear this news that really asserts their inherent jurisdiction over their children as well. And we're very excited to work with our First Nations to start developing their own traditional laws. Many of our communities are fly-in communities, and many of our young families have to leave our remote communities to access special needs services for their children, to access education services. So there's a lot of areas that we need to work on as a result of this new announcement.
In other news, the parents of a man who died last month after an interaction with Winnipeg police is speaking out. Both hope his death highlights the need for systemic change and cultural training within law enforcement. Tamara Pimentel reports.
It's very hard to lose somebody in this way. It shouldn't have happened. There's no need for what they did to my son.
The parents of James Wood speak publicly for the first time since the 35-year-old father of 7 died following a Winnipeg police interaction 2 weeks ago. Carol and Brian Wood say police brutality and systemic racism led to their son's death. They are calling for justice.
As parents, we are living through a nightmare that no one should ever have to experience. Our beloved son, James, was a kind-hearted and loving individual, was taken from us in a horrifying and senseless manner.
A bystander recorded the incident on January 27th. In the video, James appeared to be unresponsive as police carry him to a cruiser. According to WPS, Winnipeg police were called by his girlfriend, who said James was intoxicated. Moments later, another caller said he collapsed outside in a parking lot. Police arrived soon after and restrained him. Witnesses told media they believe he had been tasered by police. James was taken to hospital where he later died.
We continue to experience loss after loss, tragedy after tragedy. Our hearts are heavy. Our hearts are broken continuously.
James' aunt, Hilda Anderson Piers, has spent over 20 years advocating for Indigenous rights.
We've been victimized right from birth until we die by these systems of oppression. Enough is enough. I call on all levels of government to take meaningful action.
The Independent Investigative Unit of Manitoba is investigating the incident. James' body will be brought home to Opipinapawan Cree Nation over the weekend, where he will be laid to rest. Tamara Pimentel, APTN National News, Winnipeg.
And finally, charges of fraudulent claims to Inuit status against sisters Amira and Nadia Gill have been dropped by the Nunavut Court of Justice. Trevor Wright explains.
Charges against Amira and Nadia Gill were dropped. Their mother, Karima Manji, pled guilty to defrauding the Kikitani Inuit Association, Nunavut Tungavik Incorporated, and the Kakiavik Association of services and money over $5,000. Manji stated in an agreed statement of facts that her daughters didn't know their NTI cards were fraudulent. Amira and Nadia had official Inuit beneficiary status between February 2016 and March 2023. Between September 2020 and March 2023, the twins received over $150,000 meant for Inuit. In an agreed statement of facts, Manji stated Amira and Nadia are her birth children, but she enrolled them as Inuit in 2016, claiming that Kitty Noah of Iqaluit was the birth mother. The Iqaluit Community Enrollment Committee subsequently approved their Inuit status. Both daughters had that status removed in April 2023. The statement of facts also says Karima Manji herself applied for Inuit status in 2018 but was unsuccessful. Sentencing for Manji will be in the Nunavut Court of Justice on June 24, 2024. Trevor Wright, APTN National News, Iqaluit.
And that's your APTN News Brief for Friday, February 12th. I'm Rick Harp.